it's an engagement, and then that takes me into the compilation of the prosecution memorandum.
Which then would give you some level of insight into the
Level of
dockets and the
insight,
evidence?
yes.
Okay.
Yes.
So it's not so rigid.
No, I'm not saying I'm oblivious.
Yes.
But there may be details I miss, but it is, a lot of it is, it's in dockets, it's in documents, I get briefings, we have an engagement, and from there I'm able to take it forward.
What's the best thing to do in the circumstances? Is it to delete the last sentence altogether? Because with the insight that you accept to actually get to have, then that sentence does not make sense whatsoever. Don't we just delete that sentence?
On paragraph 11.4.
11.4, yes. The briefings, the sessions that you have with the investigators, that leads to you having an insight as you've just accepted as Ms. Sildo is engaging you.
Yes,
the effect of that is that the last sentence must go.
Yes, because the insight does not per se mean I was reading through the dockets. In the way that I am informed or briefed, I therefore have insight into the evidence.
Yes.
That is correct, Chair.
All right.
Thank you, Chair.
Sorry, Advocate Johnson, it goes further than that. Remember that letter I referred you to from the DPP, where they say they concur with your decision to prosecute. What they seem to be saying is that you made the decision to prosecute, they agree with you. So this paragraph, you can't read it with that letter and they mean the same thing. So when you say they make prosecution decisions, that's not what that letter says. That letter said you made a decision, they concur with your decision. So which is which?
I think it's in the nature of how that communication is. As the ID, I sent the memorandum. We captured the essence of the charges, who is to be charged, where the matter is to be enrolled, and the document comes from me. So when they respond, Chair, they respond to me and my decision, because as the head of office, I communicate the decision.
Yes.
And to communicate that decision, Commissioner Khumalo, I must have reconciled myself with that decision.
But you must also, because you see, there are two ways of looking at it. One is to say, we have investigated this case. These are all the facts. Please look at all the facts and decide whether this person should be prosecuted or not. That's one way of looking at it. The other way of looking at it is that you say, we have conducted an investigation, we've prepared a charge sheet, I'm satisfied that there's a prima facie case, I have made a decision to prosecute, and all they have to do is to say, I agree or I don't agree. So is it the first one or the second one?
The second one being from the DPP office.
From you, do you convey to the DPP that you've made a decision to prosecute, that this case should be prosecuted?
Yes.
Is that the decision you make?
Yes.
And that is what you communicate?
That is what is communicated. Okay. I would just need to check the wording. Do I say I made the decision to prosecute, or there's a decision to prosecute by the team? I would just need to check those words. Not to abdicate any responsibilities, but I should be clear about how I wrote it in there.
Maybe let's look at the letter. It will help you.
Whilst we look, I was about to say, surely the decision must be yours. When you communicate with the DPP, it's your decision. Yes, what you may have been told is relevant to you then deciding.
File 6, Advocate Johnson, File 6, 2438.
Commissioner Kumalo, 24.
38.
Yes, I see that.
Yes, look at the last part of paragraph 3.
And I concur with your decision to charge them on the offences set out in the charge sheet.
Yes. So what the DPP is concurring with is your decision to charge them.
As communicated in the prosecution memo.
So that presupposes that you had made a decision to charge.
That is correct, sir.
Yes. So what is stated in 11.4 of your statement is not correct then, or at least needs to be qualified.
Let's go to 11.4. Prosecutors independently evaluate the evidence and make prosecution decisions. I perform an oversight function. And adjudicating the evidence in this and other matters.
So, Advocate Johnson, so as not to put words in your mouth, what we are trying to fix for now is paragraph 11.4 of your statement,
Yes.
to make sure that it is as accurate as possible. So in your own words, how do you want 11.4 to be recorded? Now that you've seen this letter, hopefully it has jogged your memory.
So prosecutors independently evaluate the evidence and make prosecution decisions.
Are these internal IDAC prosecutors?
Internal IDAC prosecutors.
So,
In terms of that oversight function, they then present the evidence to me.
To you, I'm sorry. I'm thinking aloud, sorry.
As long as it makes sense. They then present the evidence to me.
yes.
Once they have presented the evidence, commissioners, more often than not, it is an oral briefing. They will then put together a draft prosecution memo. I then have to go through that memo, see if I agree with what is in there, and therefore endorse the prosecution decision, which then becomes my decision, which is conveyed. It is therefore where I say I compiled the prosecution memo, because in order for me to do that, I need a lot of the information and the evidence put together in a specific way so that I'm able to apply my mind to that prosecution decision and the conveyance thereof to the office of the DPP.
So your decision is then conveyed to the office of the DPP?
That is correct.
And then paragraph 3 of that letter is correct?
It is correct.
Thank you.
Because the DPP commissioner receives the prosecution memo from myself and therefore responds to myself.
Thank you, Commissioners. Before we leave your response to paragraph 2.2, an issue arose, I think, in your in the engagement Commissioner Baloyi had with you regarding what you specifically, whether or not you invoked the sub judice rule before ad hoc. When we break for tea, you might want to consider, for the record, CJC 375, Exhibit CJC 375. That is the transcript of your testimony before the ad hoc committee. Just make a note of the exhibit number. We will assist you to
And the
locate
file? It's CJC
it.
37.
CJC 375.
Yes, ma'am.
Yeah, CJC 375, please take note. It's file 3, I'm told. The most important thing is the exhibit number. That is your transcript, the transcript of your testimony before ad hoc. So I suggest over the course of lunch, you cast your eye there to see whether or not, to the question posed, whether you did raise the sub judice rule before ad hoc.
I will do that.
Thank you. If we go over, leave then on your statement, we're at page 6 of your statement, you deal with questions or issues raised in paragraphs 2.3 and 2.4 of the subpoena. You give a singular response, I think, to that. So I will read both 2.3 and 2.4. 2.3 reads thus, quote, allegations concerning your role in interference in criminal investigations and prosecutions, close quote. Sub 2.4, the effect, open quote, the effect of such conduct on the functioning, integrity, and independence of the criminal justice system, close quote. You respond to both of those from your paragraph 12 at page 6 of your supplementary statement. If you could then turn to deal with that. Thank you.
At paragraph 12, Commissioners, at paragraphs 2.3 and 2.4, I deny any allegation that I interfered in criminal investigations or prosecutions. This allegation is, in any event, vague and unsupported by particulars. I expand on this denial as follows hereunder. I say that the allegations is vague because it does not identify the investigation or prosecution allegedly interfered with, the date or period of the alleged interference, the person allegedly influenced, the decision allegedly affected, or the manner in which the alleged interference occurred. In paragraph 13, IDAC operates on a prosecution-led investigative methodology that I head. Investigators conduct investigations and present evidence to prosecutors in their teams. Prosecutors then evaluate the facts and evidence and decide whether to prosecute. That decision is confirmed by the DDPP, is the Deputy Director of Public Prosecutions, Commissioners, in the group. Matters, paragraph 14, matters are presented to the investigating director and senior managers before arrest as part of the oversight function. I have not instructed, pressured, induced, prevented, delayed, or otherwise influenced any investigator or prosecutor to act other than in accordance with the evidence, the law, and the applicable prosecutorial policy.
Thank you. Thank you. I take it reference at paragraph 14 to the investigating director is reference to yourself, am I correct?
That is correct.
And you say matters are presented to you then and senior managers before arrest as part of the oversight function. Can you briefly tell the commissioners what your oversight function entails?
When teams are ready to execute arrests, it becomes important to determine that they have done, they have all the necessary documents, that they have fulfilled the evidential burden, and what operational and or resource support they might require. So when they make this presentation to the ID and senior managers, their commissioners could include senior investigators, other senior prosecutors, etc. And what happens is the team that is preparing to conduct an operation must prepare to people that are not present to people that are not in their team. So it would invariably be other managers of equal ranks of other persons also from that team. And when they present, they would make a PowerPoint presentation. Sometimes some of them, them being the lawyers they would want to speak off the cuff, but they would give you a briefing of the evidence, how persons are linked to the allegations, which persons are linked to the allegations, a brief summary of what evidence they rely on, and then to indicate who it is they intend to arrest. Do they intend to search? Do they have arrest warrants? Do they have search warrants? Are they going to be just, and forgive my language, ordinary searches, or are they going to be cyber searches? Where these are going to take place. And that is the general gist of that kind of briefing. And once myself and the other senior managers have left, that team gets together with other officials to plan the logistics of who goes where, what resources are required, and so on. But it is just in order to understand that their matter is ready.
Thank you. Then just to clarify, lastly, on that particular paragraph, on paragraph 14, you say you have not instructed or otherwise influenced any investigator or prosecutor to act other than in accordance with the evidence, the law, the applicable prosecutorial policy. I appreciate what you are communicating here to be that there was no undue influence from you on. My question is, did you, in the course of being briefed and having the presentations made to you, and in the exercise of your oversight function, do you have scope to instruct, advise, influence investigations? And I say so, you doing so in accordance with the law. I'm not imputing any undue, unlawful influence, but are you, as the investigating director, able to influence the direction, outcome, disagree with what is presented to you, and therefore influence the eventual outcome of the investigation, or you have no scope at all in that regard?
It is not to seek to influence. In those presentations, myself and whomever the other managers are that are present are allowed to engage with the presentation. Sometimes it may not be as clear how a person is linked. There might be questions around a witness. Why do you have a 204 witness? What do you have that corroborates? It's almost like a moot court without the presiding officers, but it is an engagement of the matter. So everyone can ask questions because they thought they were ready, and other managers in the office took issue with perhaps how things were incomplete or what more you needed. So that allows for them to come back again. They would have to deal with that before they then, and there have been matters, just one last thing, even when if the investigating director is not in the office, it doesn't mean these operations don't happen.
Yes.
There are other senior persons. The head of operations, Mr. Sissoko, is there, together with other senior managers, and they would convene in a similar fashion.
So if there are glaring anomalies in the either investigation or conclusions reached pursuant to investigations, there is scope in the exercise of your oversight function to draw attention to that, and it gets redressed.
And to send the matter back.
Indeed.
For those to be addressed. And if they are not addressed, then that's a different discussion, because not having addressed does not take the matter forward.
Absolutely. I'm clarified. Thank you so much.
Can I?
We then,
Can I?
yes, ma'am.
In that exchange where you say there's consultation and discussions and debate, do you have are you able to say, I disagree, and so it will not happen? And I want to give you a more direct example on a topic that will come up for discussion later, that if your team puts forward to this discussion that we intend to go and arrest Commissioner Khumalo, because that's who we are investigating.
He's saying he doesn't want to be arrested.
And are you able, do you have the standing, and this is a question really that takes us to standard operating procedures, protocols, or is this one of those where we work it out as we go along? You know, in practice, this is how we do it. Are you in a position to say, no, we are not arresting, we are summoning? Because we know, for example, that you have summoned some of the people that
Correct.
you have had charged.
Yes.
Yet others have been placed under arrest, either at a police station or at an airport or something. Is it your final decision to say we are not arresting, we are summoning, or that decision rests with somebody else, and irrespective of what you think about it?
I am able to make my feelings known. And there is an engagement on why. There are certain things investigators take into account in how best to secure a person. But there is room for engagement. But apart from that, there have been times when I have disagreed, simply because I think the purpose of the exercise must be what is the best way to secure the attendance of a person in court. That has always been the legal principle. And so there have been instances where we have subpoenaed, and there are instances where you have the warrant, but instead of going and executing the warrant, as an example, at a person's home or place of business, you call them and ask them to hand themselves over, and then you do that processing. Those are the ones that are preferred, so as not to be invasive in terms of their space. Sometimes investigators think a bit differently, Commissioner Baloy, but I'm able to, and there's a lot of other considerations, especially where people have families.
Yes, I guess my question more directly is, out of the process that you've described of a team presenting to other managers who are not involved in the matter, and you also participate in that, where does the final decision lies out of that process? Who makes the final decision? I appreciate it's a team discussion and it involves back and forth, but ultimately somebody makes a decision, and you are head of institution. I don't want to assume that because you are head, you are the one that makes the decision. So it's your opportunity to say that, well, finally the decision rests with you. You let it be a team decision, but in fact the decision rests with you finally. That's what I'm trying to determine with my question.
I am able to make input. A lot of the times the input is taken on board. When myself and those managers who are being briefed leave the room, you have a lead prosecutor and lead investigator, and they also have the benefit of the two chief criminal investigators, as well as Mr. Sissoko, who's the head of operations. And they will deliberate on what we have suggested, and they take it on board and make the final decision, because the execution is theirs, not the ID.
So out of that process, the final decision is not yours?
It's not my final decision.
It's made by other people?
Yes.
Okay, thank you.
And we'll come back to this just so I understand. On specifically the aspect Commissioner Baloy just engaged you on, whether or not an accused person is arrested or summoned to court, you say it's not your final decision. It's not yours. It lies somewhere else within IDAC.
It lies with that team.
So where that team has made that decision, you have no power to overturn it as the ID. Is that? I just need to understand what your power is relative to that decision taken by investigators. Do you have any powers at all?
We haven't exercised powers to overturn. We've made suggestions, and almost invariably many of those suggestions have been taken on board. So as an example, Advocate Selo, the team might feel strongly about an arrest. And in that engagement, the ID says, the reasons you provide just don't make sense for why a warrant of arrest, a subpoena should be issued. They then take that on board and I found that they do exercise it. So they do listen when it makes sense that the proposed way they wanted was not going to work.
You talk about you haven't exercised the power. I am still trying to locate the power. Do you have that power as a matter of fact and law, or you don't?
No, I don't.
Whether you have exercised it or not is neither here nor there for the moment. Do you understand yourself to have such a power?
No.
No.
It is a power of engagement. What I'm saying is I engage them and I make suggestions. I cannot take the decision for them. I can make a suggestion, not a warrant, a subpoena.
No, I get confused now just when I thought I got it. You don't take a decision for them. They have taken a decision. My question is, do you have the power to override that decision? It's either you have it, you don't, and I'll move on.
I haven't exercised such a power to override.
I have
to check if I have such a power to override.
Advocate Johnson, I'm hungry too, it's lunch. You can only exercise it if you have it.
Yes.
But you are not answering the first question. Do you understand yourself to have it or not to have it at all, that power?
I don't have a power to override them.
Okay.
From what I understand.
All right. Okay. That then I think that takes care of paragraphs 2 and 3. We deal with paragraph 2.5 in the subpoena, which reads thus: required you to address, quote, allegations concerning the existence of a quote-unquote Khan-IDAC cabal in SAPS and your role pursuant thereto, as made by Mr. Thulani Shongwe during his evidence at the Commission on the 30th of June 2026, close quote. You deal with that from your paragraph 15 at page 6 of your supplementary statement.
At paragraph 2.5, I have no knowledge of the existence of a Khan-IDAC cabal in SAPS. I also have no knowledge of a Khan-IDAC cabal within the IDAC. It follows that if such a cabal exists, I am not party to it. I have not authorized, encouraged, or facilitated its existence, nor have I benefited from any unlawful association involving General Khan, IDAC, SAPS officials, or any other person. To the extent that Mr. Thulani Shongwe's evidence suggests otherwise, I deny that suggestion.
And thank you. That will then take us to, I think your answer is straightforward and clear. Paragraph 2.6 of the subpoena, which reads thus, I quote, your relationship with Major General Khan and allegations against him, close quote. You deal with that paragraph 2.6, starting from your paragraph 16 at page 7. If you could turn to that, please.
At paragraph 2.6, I know Major General Khan, as a general based at Crime Intelligence Head Office. Before I became the investigating director in March 2022, I engaged with him in meetings with other stakeholders, attended net joints or other SAPS meetings at which he was present and to which I had been invited by relevant component heads, deputy national commissioners or divisional commissioners. In late 2024, media reports emerged concerning General Khan's alleged involvement with persons allegedly linked to the Murray murders. Those reports concerned me because I had previously met with one of the Murray sons who wanted to know whether IDAC could assist with the investigation. I informed him that IDAC could not assist, but explained how he could escalate his concerns about the investigation to SAPS management. At that stage, the concerns of the Murray's son referred to above related to how SAPS organized crime Gauteng was dealing with the matter. 18, I later encountered General Khan at a Public Service Commission or Department of Public Service and Administration workshop. I asked to speak to him and told him that the media reports about his alleged involvement with persons linked to the Murray murders were concerning. I further stated that if evidence of criminality by him were brought to IDAC, it would be dealt with in accordance with the law. 19, after the engagement referred to above, I had very limited contact with General Khan, and I've had no contact with him for approximately the past year and a half. The allegation referred to above is also vague and unsupported by particulars. No particulars have been provided as to who made the allegations, which docket is implicated, when or where the alleged disclosure occurred, how the docket was allegedly disclosed, or what information was allegedly conveyed. This is a serious allegation to make against a person holding as high a position of responsibility as I do, so that I, Chair, would justifiably have expected particularity to accompany the allegations for any meaningful engagement with them. Should I be required to answer questions arising from this affidavit or any other matters in respect of which it is determined that I may assist the Commission, I am willing to make myself available, subject to reasonable notice, access to sufficient evidential material to which I am required to respond, and my rights to legal representation. That ends the affidavit.
Thank you. Just two questions for clarity. At paragraph 16, you do state that you know Major General Khan as a general based at Crime Intelligence Head Office. Before I became the investigating director in March, I engaged with him in meetings with other stakeholders. So we are now before you joined IDAC. Did you have any other relationship besides that you describe at paragraph 16 with General Khan, personal
Yes.
or otherwise?
I had gotten to know him quite well. At a stage, we engaged often on all kinds of issues that didn't necessarily relate to work. He was very affable, and I got along with him. So I would talk to him as well outside of meetings. It wasn't confined to meetings.
That's an important distinction to draw, because your paragraph 16 seems to suggest that your engagements with him prior to 2022 were in meetings and with other stakeholders only. It's too restrictive what's said in 16 regard being had to your response now.
And we can add it.
No, the record, it's there on record. So I say, we clarified that you had this professional relationship as you described in 16, but you also had a personal relationship with
Yes,
him.
I did.
You say you then you have a specific timeline to it, say before I became investigating director in March 2022. Let's get past March 2022. The relationship, as you have now clarified, with General Khan, did it change? What's the relevance of using that marker, March 22, when you became ID, to speaking to the relationship you have with General Khan? It suggests, as I read it, that it drastically changed from March 2022. Am I reading it correctly? And yet, I take into consideration what you say